Greetings, everybody. This is Archangel Macintosh, aka Archangel Mikael, Israel. From the 12 tribes of the Hebrew Israelites, specifically Lawaya, the Levites, the Haitians, and Yahawada, which is Judah, the so-called Negroes which migrated from Africa to over here in America. I hope you guys are ready. A lot of people have been asking me questions about how to conduct liens. What does a lien conduct of, or what do you need to make a perfected lien on personal property, private property? It can be on your house, it can be on your children, it can be on your vehicle, your house, whatever it may be. Or if someone owe you money and they haven't paid you back for it, and you already went through the affidavit process, writing them an affidavit of claim, and then you send them the 3 defaults and warning them that you may place a lien on them. If you're wanting to learn how to actually place that lien on them, this is what we're going to learn today through this document. This information is not mine, by the way. I've already read it. It's a very powerful information. It will definitely help you comprehend the whole process of liens and what are liens, what are they used for, and when to use them. Because a lien is pretty much how we sue anybody in the system that has committed a tort towards us, which is a wrongdoing, or anyone who has injured us in any way, shape, manner, or form, or if anyone has taken something away from us without our permission. This is our final backup right here. One of the last things that you can do before you go to court to fight it. So if you want to look for this information, you can go to this website right here. I'm gonna go ahead and start reading because there is a few pages to this book, so we're gonna go ahead and begin now. Make sure your pencil is ready, or your pen, or whatever you take notes on, your pad, and make sure you take notes as you go. I hope you guys enjoy this and journey well. Shalom. Commercial liens. And lien means interest. So you're having a commercial interest, a corporate interest, a financial interest, financial lien. A most potent weapon, version 1.0, edited by Terra Libra staff, with acknowledgments and credit to Alfred Adask, publisher of Anti-Shyster magazine, Richard Boylebay, and David David D. Raymer, and the various lien authors for providing some of the content applicable to the United States of America, adaptable for some other countries because our laws are similar. And this is they copyright their property through common law right, which I already taught you guys how to do if you looked at my copyright and trademark video. This is a common law copyright, copywritten in 1995 by Terra Libra Holdings. All her rights are reserved. And this is her notice. This document is free for personal use only. No part of these materials may be produced in any form except for personal use without permission from the copyright holder. And my legal disclaimer is that I'm sharing this for entertainment and educational purposes only. It's pretty much me reading it to myself, but it happens to be on video. Alright, so let's go ahead and continue. These are the table of contents, what we're going to be learning. Scope and purpose of the manual, the introduction to the manual, some notes on the sample briefs, because they're going to show us samples, the commercial lien strategy, the background behind it, some examples of the strategy, the power of commercial liens. So chapter 2, we're going to learn about theory of commercial lien strategy, another introduction to the commercial lien strategy, the commercial affidavit process, because you need to make the affidavits before you start doing commercial liens or it's invalid. Constitutions as enforceable contracts, because in the Constitution of America it states that we have unlimited right to contract and not contract. Bonding of government officials, because this is important too, because many of the government officials are under bonds, and these bonds are commercial bonds. and their commercial bonds have commercial value. You see what I'm saying? So you can have a commercial interest in their commercial bonds and stuff like that, which we'll learn in that section. Because bonds are money. Just like promissory notes, acceptance for values and all that stuff is all money. Your signature is money. They're bonds. Bond means contract, like love and marriage. So see the unification between all these terms and words. Chapter 3, we're going to be learning the basic concepts of liens. Lien definition, what is the definition of it? Different types of liens, comparisons, and liens versus levies. Chapter 4, we're going to be learning about procedure and implementation, because you need to implement what you're stating in your liens, and you need to know how to enforce it, or it doesn't mean much. It'll just be sitting there. Research, notice and demand, notice of default, commercial lien, lawsuits and criminal complaints. Chapter 5, we're going to be learning about mistakes and pitfalls to avoid, defective legal form and procedure, Hansen type or nebulous liens, aiming too high, because if you're aiming too high, your liens can fail too. You want to make sure it's realistic so you can get something from it. And beware of exotic arguments. Chapter 6, obstacles and strategies for overcoming them. Refusal to file liens, if they refuse to file your liens. Abuse of judicial power. And we're going to talk about the abuse of court power and judicial power when it comes to getting your remedies. You see what I'm saying? Because we all have some type of remedy, some type of cure in this legal fictitious game. So in chapter 7, we're going to be learning about the coloring agreement approach, the color of law agreement, because all statutes of color of law is based on assumption, mask, deception, avail, curtain, hiding, covetousness, code, secrets. All that has to do with color, veil, to mask something, to color it, to smother it. Background and instructions. Chapter 8, we're going to be learning about the final thoughts by Alfred Adask, and we'll have the Appendix A and Appendix B for bibliography and sources where this information is being found and scouted from, an index of sample legal briefs. So it'll show some samples at the end. So chapter 1, introduction. Disclaimer. This manual is intended purely as a communication of information in accordance with the right of free speech. It does not constitute either general or specific legal advice. Anyone seeking legal advice should consult a competent professional. Neither the author, editor, or publisher, or me guarantee that using this information will result in success or protect the reader from harm. The reader must accept that risk and thoroughly study the law before using any of this material. Readers must take full responsibility for the consequences of any actions taken based on this material. Pardon me. The reader must, pardon me. For most readers, you may well be best off reading this For most readers, you may well be best off reading this as a sort of adventure novel. You can learn of some of the actual documents and procedures being used by many freedom fighters. If you were to actually use these documents and procedures, you would probably be at substantial risk to change your life in very major ways, some of which may be very unpleasant. So if you don't know what you're doing, please don't use this info until you thoroughly study it. See, I know what I'm doing. This adds on to what I know. But for you, some of you guys who are new to this, make sure you do your due diligent research. Research everybody else's opinions about these things and their own insights and their own perception, and piece something together to get the overall view of what's going on. Because if you don't get the overall view of this, there's no point of doing this, no matter how great your paperwork sounds. You need the knowledge and the light before you start using it. You see? Because they will test you, and the creator will test you. Something will test you. So know what you're saying before you say it. The use of commercial liens are described in this manual is extremely high profile. For most readers, it may be advisable to use some of the lower profile applications of freedom technology, which means you're going to be exposing yourself a lot. You see, you're going to be entering into a war now with those who never wanted you to know these things about the system. So from studying this and knowing this and using this information to free yourself, to redeem your spirit and to redeem your physical life, you're pretty much entering into a war. You see what I'm saying? Because they don't want you to know this. They didn't expect you to know this. This information is not supposed to be known, although everyone in the system uses it. The mortgage people use liens on you. The debtors use liens on you. The IRS use liens on you, and affidavits and notes and paperwork and mailing letters to you and all that stuff. So you need to know how to do the same thing and fight them in their war and beat them at their war until you can redeem yourself from this game, from the many webs and the attachments trying to tangle you down in this bullshit. So generally, we think that rather than fight existing systems, it's much more productive, useful, and exciting to create alternative new systems. Let's create a new way once we know all this stuff. This disclaimer is especially important because this is a relatively new strategy and has not yet been subjected to a Supreme Court challenge. Until that takes place, the soundness of this strategy cannot be fully known. The commercial lien strategy is still evolving, and new information is being discovered daily. If you use this strategy, who knows? Your name may be on a famous Supreme Court case. You never know. Whether that prospect thrills you or disturbs you depends upon your outlook. I wanna make sure I free myself. If something don't apply to me, it don't apply to me, and I'm gonna make sure that is known. And that goes for everybody, because no one should be enforcing on you laws that do not apply to you. They can't enforce contracts on you that you do not consent to or give permission to. You see, so these liens are supposed to penalize them in a way and punish them so they can stop doing what they're doing, or continue to be punished by all the competent people in this world. So these liens, because they are so powerful, should be treated with respect. We at Terra Libra do not advocate the use of these liens against all government officials, nor to any official in particular. We honor the fact that there are many virtuous people in government offices who are truly striving to harm no one and to benefit as many people in society as possible. So have discernment, know who to use this weapon on and who not to use it on, like a gun. The liens described in this manual are not directed towards these harmless officials, but the harmful ones. Scope and purpose of manual. This manual is an introduction and premiere to the commercial lien strategy. It does not pretend to be the final word on the subject. The authors and editors have synthesized material from several sources. We have organized it into a form that should be comprehensible to the average reader. After reading this manual, you will know the fundamental principles of this strategy. This understanding, plus the bibliography in Appendix A, will allow you to do further research on your own. Some notes on the sample briefs. Included with this manual is an appendix containing sample legal briefs based upon actual examples used by others. You will have to reformat these briefs templates using your word processing software, and you must adapt them to your situation and to the requirements of your state or locality. These are not, and in the nature of things, rerum natura, cannot be fill in the blank forms. You must custom make it to your own situation. You see, that's all you have to do. Custom make it to your situation, but keep the format the same. Unless you know what you're doing, because you are the creditor. You are the creator of that paperwork, and you are the life bringer of it, the creator of it, the person who's actually investing life in this paperwork. You see what I'm saying? Before you said, let there be light, let it come to life. So when you write your work and you write your affidavits and things like that, make sure you custom make it to your own particular situation and circumstance, and include everything that you need to include to give evidence to what you were expressing or what you were claiming. Because you need evidence, you need proof, you need something. You see? Receipts, something. The commercial lien strategy background. Faced with corrupt lawyers and judges, no litigant can expect to win in court by simply playing defense. To beat them, you must be able to scare them. You must be able to make them respect you. And that means you must be able to take the offense, attack them personally. Unfortunately, judges, lawyers, and other government officials enjoy various levels of personal immunity provided by both law and professional courtesy. How do you sue a lawyer for malpractice? You hire another lawyer if you can find one who'll take the case. How do you sue an IRS agent, Internal Revenue Service agent, for violating your constitutional or natural law rights? Only with great difficulty. How you sue a judge for railroading you in court? You don't. Most people just don't, because they don't know how to. As a practical matter, private citizens can sue the President of the United States, a governor, judge, or even an IRS agent for failing to obey or enforce the laws. If we try to sue in court to compel our government officials to obey the law and perform their lawful duties, the judges routinely ignore our petitions, our requests, our commands, demands, and laugh us out of court. Because legal and de facto, which means it's not factual. They're not legal. They don't have the authority to be doing what they're doing. They're de facto. And legal mean man-made. So because man-made and disfactual immunities shield government personnel from being sued for committing crimes against the people, natural common law crimes like stealing from the people, hurting the people, and lying about the people, all that's harming us. The public is legally disarmed, unable to aggressively sue the government or its agents and compel them to obey the law, the natural laws. As a result, the public's legal posture is fundamentally defensive. We try to duck, dodge, and hide in legal loopholes to defend ourselves against the government and the courts. We try to escape, evade, flee, and avoid, but we seldom counterattack against our antagonists, largely because we think there are no lawful weapons to do so, to take them out, to sue them, to make them give up everything that they have, to make them surrender their position in office as an official, for committing treason, lying on their oath and lying about their oath, and claiming that they're going to protect and serve us, and committing perjury. Instead, we simply file a lien that encompasses the official's personal property and credit rating like a ton of bricks until he voluntarily satisfies our demand to perform his or her lawful duty, and we, in turn, voluntarily agree to excise the lien. So we'll get rid of the lien if they respect us and stop trying to take our stuff from us, injuring us. Because do unto others what you want others to do unto you. That is a natural common law right. You see what I'm saying? And it's also in the holy book. Do unto others what you want others to do to you. And thou shalt not steal, which means you should not steal. And if you're stepping on someone's will and you're invading their right to consent and not consent, and the right to contract and no contract, you're pretty much stealing and robbing someone of their rights, of their will. You see what I'm saying? So thou shalt not steal. And thou shalt not commit adultery, which means the Creator and the Most High, the Almighty I Am, pure white light spirit, comes before anything and everything else. Because it's the Creator that creates everything. And it's the Creator that credits us the sunlight, the sun, the stars, the moon, the oceans, and everything that flourishes in it. Therefore, it's the Creator that credits us life and credits us the right to have property and everything. And the Creator says that we're in His image, therefore this is our land, this is our creation. You see what I'm saying? So they cannot intrude and invade or trespass on your will and consent. And silence is consent. But you must say something. You cannot dodge and avoid it. So some examples of the strategy. Example 1. Edward J. Wagner, an hourly unionized employee at General Electric (GE) received notice of levy from the IRS, which mean they're gonna start taking his property to fulfill a debt. Levy mean they're taking a claim on your property, on your wages, on your property, on your children, on your house, or whatever collateral you may have put up to fulfill the indebtedness or how much you owe them. So that's what a levy is. So with this particular person, they were garnishing his wages and monies received from several other sources. So they were just attacking this person from every angle of his life for no reason. And it's only because of a notice. So everything begins with a notice or affidavit. Wagner tried to persuade GE not to honor the notices since they were not properly attested as true bills of commerce. And true bills of commerce would be receipts, evidence, proof, contract, jurisdiction. If they don't have like a true bill, a true receipt, a true contract, then they don't have a legally binding contract or a lawfully binding contract, which means the contract is nullable. It can be null and void, ab initio, from the beginning, because it's not a bilateral contract, which means it's not a contract running both ways, where you wrote them a contract and they wrote you a contract and you guys bilaterally agreed. And on top of that, if they never disclosed to you what they were going to be doing with your information and stuff like that, or the true intent of the contract, then it's nullifiable. It's not a true bill of commerce, you see? So his efforts met with no success, unfortunately, just taking the defense side. Because arguing the contract is arguing, and arguing is defense. If you're defending, you're a defendant. And if you're a defendant and you're defending, that means you're a debtor. You see? So automatically, the way you speak can turn the tables on you or on the other person. You got to speak like a creditor. Conditionally accept the charges and stuff like that if they can produce a true bill of commerce. You see what I'm saying? You can say something like that, conditionally accept all the charges if you can prove that, if you can prove your claim, pretty much. Don't go in there saying, oh, that I don't have no contract with them, because that's defending. So, alright, so after giving GE proper notice and demand, because you need to give them the proper notice and demand, Wagner and his wife filed a commercial lien in the amount of $224,640. Well, I believe that he meant million. So it's 224,640,000 about. Pardon me, because they messed up right here on this number. Alright, in the lien, Wagner impounded GE inventory that he had worked on, including air conditioning units, analyzing equipment, and etc. So this is all the property that he put in the collateral section of the lien, because every lien needs a section where there's collateral, you see? So all of that was placed in there as security for the lien. Asset means security. Security is asset. Like your social security is your social asset. You see, so you have a share in the system. You are a co-owner of the system. You're a co-owner of this stuff. So this is similar to an auto mechanic impounding a car he had repaired, which is like a mechanic's lien. You see, this meant that General Electric could not lawfully sell or transfer the equipment until the lien was either extinguished or satisfied. So a lien cannot be extinguished unless it is satisfied, or unless it's rebutted point for point. It has to be disagreed with point for point, and they have to give proof why they disagree. You feel me? Or it's still a perfected lien, or they have to pay off the lien in order for the lien to disappear. Because a lien, an affidavit is someone's truth. An affidavit is stated under penalties of perjury and it's notarized. How can someone else cancel your lien and disprove you without proof that disproves it? You see, so the only way to extinguish a lien is through truth, is through proof. And if you haven't been telling the truth, the proof, then there's no way you're gonna take that lien off of your stuff. You see what I'm saying? Among the reasons for the high dollar amount are that the law allows for such high sums as rewards for damages incurred, and it generally has to be large enough in relation to the size of the company involved to get its attention. Otherwise, such a large company might just ignore it. Consequently, a legal war followed, and by June of '92, General Electric had gone to court several times trying to remove Wagner's lien, all without any real success. This was in spite of the fact that General Electric had the best, most highly paid, and highly motivated lawyers. But not even any lawyer, any man on this planet with whatever title can disprove your truth unless they can prove with proof and evidence that your truth is not truth. You see? That's the thing about affidavits. All liens are in the form of affidavit, under penalties of perjury and complete risk, and under your unlimited commercial liability. So in June of '92, the first major victory for the Wagners came. The Internal Revenue Service issued 4 different official releases of levy. One to General Electric, plus 3 other places where they had a wages and income that the IRS had levied. The Port of Seattle, Dean Witter Reynolds, and Ohio State Life Insurance Company. These effectively released the IRS's attachment on the Wagner's income and assets. That's a pretty solid testimonial to the power of the arguments in Mr. Wagner's lien. Example 2. In August 1992, Mr. Nelson Starr, who lives in Florida, filed a lien on several federal judges, the Commissioner of the Internal Revenue Services, the Attorney General of the United States, the lawyer for the United States, one or more United States attorneys for the Southern District of Florida, and several other individuals in the amount of $350,000 on each individual. The officials asked Mr. Alan Diamond, president of the Florida Bar Association, British Association, to inspect the lien and see if it was lawful or not. In spite of his desire to please his powerful friends, Diamond could not find nothing illegal about the lien. In fact, in a sworn affidavit, Diamond declared that the document causes irreparable harm to the system of the administration of justice. So the document is warning them, because if you're putting them on notice and you're warning them, then they cannot use this against you later on if it damages the system or the administration of justice irreparably. You see, if you don't put that in your notice, what you're going to do, and warn them before you do it, then most likely there's a loophole for them out of your lien, you see? So make sure you have evidence. Make sure the penalty is not too exaggerated and it's reasonable, you see, where it amounts to the damages. And also on top of that, make sure that you warn them and put them on notice of everything that you may, could, will, or would do to them if they do not let you go, if they do not discharge the charges, or if they do not release your property. You see, so now if they don't rebut that, if they don't disagree with that, they're agreeing with all of that, which means you can let hell wreak loose. You see, you can unload a can of worms in their stomach and make them throw up in their belly and in their mouth. You see what I'm saying? To the point where they're shocked that you know what you're doing and you know how to defend yourself and protect yourself from their attacks offensively now. So you got to know how to use this as a weapon at the right time and place. Hope you guys see what I'm saying. While some of the harm may be compensable at law, no degree of compensation will adequately remedy the damage to the appearance of integrity of those named and of the system of the administration of justice. In my opinion, the filing of this type of lien is a direct attack on the justice system and on the general reputations of those named in the lien. It may negatively impact on the financial credit rating of those individuals. It will probably have a negative impact on their willingness to continue to serve as representatives of the United States or America. and it constitutes an abuse of civil process that cannot be adequately remedied by an action of law. Emphasis added. In plain English, Diamond did not like the lien, but couldn't find any way to extinguish it. Further, he seemed to say that these liens could drive public officials right out of office. For libertarians and patriots, that is a powerful endorsement. Example 3. Another man in Florida filed commercial liens against 9 IRS agents and was later taken to court by the IRS agents' wives. The wives tried unsuccessfully to remove the liens because their credit cards had stopped working. So when you do these liens, you're sending them to the IRS, and the IRS is like the main headquarters for collecting debt and all that stuff. So they can hit them right through the tax office and through their income and things like that once you properly do the paperwork. And the IRS don't really study or research or look into who the people are who are sending them these liens. They just look at the debtor, the creditor, what has been stated, the evidence of it, and then they go from that. You see what I'm saying? They don't usually get both sides of the story. So whoever's sending in the lien and the request for payment or whatever it is, reimbursement, by sending the lien to IRS is the person who's going to be receiving the benefits or the remedy from the IRS or whoever it may be. Because you can also sell it to the stock market as well, to the brokers and stuff, and sell it to someone else who want to invest in that contract, and then investor will actually buy the contract, hoping to be paid by the debtor at some point with interest. You see what I'm saying? So, there's a lot of cool things you can do with this paperwork. Just a simple promise to pay or affidavit or a lien can turn into money. It can turn into account receivable. You can ledger it, which means you can turn it into an asset or a security, because a promise to pay is worth just as much as the actual payment. But if you transfer the promise to pay from you to someone else, it's just as potent, because the debtors still have to pay off the promise to pay anyway, and it truly don't matter if the original person who's supposed to get paid sell it off to another investor. So you can literally sell these debts to investors like the IRS and the stock market, broker's office, Fidelity.com and things like that. So there's a lot of dirty things and aggressive things that you can do to people who are messing with you in this legal system. You see, so use this information wisely, please. Don't go around taking everybody's house and stuff like that and wreaking harm. Should be working together and freeing each other with this information, bringing peace and prosperity. You see, that's the only reason why I share it and spend my time reading these things. So the liens had compromised their credit rating, and they couldn't go shopping except with cash. Imagine the distress the IRS agents themselves had to endure for their wives on account of these liens. Evidently, the liens hit the agents where they lived in a way that other actions at law could not do. So liens, there's no way to stop liens. No way. Except by paying it off completely or rebutting it point for point with evidence and proof. Example 4. Perhaps the most imaginative use of the commercial lien strategy is a lien by Mr. Phil Marsh of the Pilot Connection against the President of the United States Congress, the Federal Reserve, and the Commissioner of the Internal Revenue Service, IRS, on behalf of all 250 million Americans. See Appendix B6. We'll see that at the bottom. For each of the 250 million Americans, the lien demanded $10,000. Who they probably try to kill that person? Mr. Phil Marsh of the Pilot Connection. Wow. So if the lien were enforced, it would mean the government would owe the people $2.5 trillion, over half the annual gross national product, GNP. Alright, this class action lien will almost certainly never be enforced. However, if the courts find a way to extinguish it, it may have the effect of weakening the power of all liens, including the one the IRS files on us. So that might be a little loophole because of this person's over-exaggerated lien. Well, if the lien's over-exaggerated and the numbers are too large and it's too complicated, the lien doesn't stand, it's still not truth. Well, if it's still not truth and that is a loophole, then that might be a loophole for us too out of certain liens we're in, especially as a country and a nation, because our nation's in debt because of us. We're not working as a unit of creditors, world creditors and the national creditors to discharge all our debts. You see, because we have the ability to discharge debts because HJR 192 of June 5th, 1995, which is House Joint Resolution. Because they lost all our gold and silver to England from whatever gamble that they pretty much took a risk in gambling in, and they lost our money in the gamble, which is gold and silver, they owe us, the people, money. That's why they issued promise to pay notes and unlimited credit. We have unlimited credit, and they created a birth certificate and social to give proof that you are a creditor of the United States corporation, their private corporation, you see? So they owe you money, you have unlimited credit, your social security, the numbers on the back is your account number and routing number. You can use it to discharge debt. The number on the front of your social security is your cattle number, which is the number of your corporation or your person or your legal entity or your straw man, whatever you want to call it and stuff, because you're not the same as that all capital name spelled legal fiction. That's his cattle number on the front, and the birth certificate is proof that a corporation was birthed, that corporation was created and stuff. An artificial person was created. So you can use all this paperwork and these documents and contract to discharge your debt and state your position. You see, but you must know how to use it in the proper way so you're not being seen as if you are the legal fiction or the debtor or things like that. Because most likely the injuries that's going to happen to you is based on them assuming and prejudging that you are the straw man. And this is always the case with court, with your work, with taxes, with mortgages, everything, statutes, all that stuff has to do with the straw man. So if you haven't learned about that, check out my other videos on my page because I explained all of this already. This is an addition to what I've already stated numerous of times. So let's see. So editors know everything in this manual is information only, not legal advice. So it's entertainment. This caveat applies with particular force to Mr. Marsh's lien. We present this lien as an interesting and imaginative application of the commercial lien strategy, not as an endorsement, approval. Terra Libra originally included Phil Marsh and the Pilot Connection on our list of sources. However, some of our customers began to complain about poor service, and some raised questions about the integrity of the group. Later, Marsh appeared on the television show 2020 and vigorously denounced the IRS. Also, it appears that the Pilot Connection may have been stockpiling arms and ammunition. These actions invited official retaliation, which was not long in coming. You drawing that type of attention, no wonder why they coming down on you so hard. Shouldn't be drawing that much attention to yourself, and I know I'm drawing attention to myself by sharing this information with y'all, but someone got to do this. The truth must be heard. In 1994, Phil Marsh and other members of the Pilot Connection were prosecuted by federal territorial gangsters on a smorgasbord of criminal charges. So a large number of charges, numerous charges. In November of that year, the trial ended in a hung jury on most counts and a few outright acquittals with no convictions. Acquittals would mean to pardon me, hold on, let me see. Acquittals. Hold on, let me look for it again. Boom. I know acquittals either to take something out or to acquire. Hold on. Oh, okay, to take out. To take out. It means to literally take out. So it's the legal and formal certification of the innocence of a person who has been charged with a crime, a setting free from the charge of an offense by verdict. So alright, that's pretty much what it means, acquittal. Alright, let's continue on. So no convictions. The defense team included public defenders and 2 experienced pro se litigants. Not pro per, but pro se litigants. You, when you speak, you want to be in the angle of a pro per. And your appropriate persona, your appropriate personality, your appropriate persona. This is pro se. This is more like when you're foreign. You know, when you're foreign, when you're working for the bar association, for the government, you're working in pro se, which means you work for the government and you're defending yourself. You're representing yourself. Pro se mean you're representing yourself. You see what I'm saying? But you're not the straw man, so you're not representing yourself. You are the authorized representative. You see, that doesn't mean you're representing the principal straw man. You are an authorized representative of the straw man, which means you are in your appropriate personality as an authorized representative in pro per. So, and 2 experienced pro se litigants from the National Commodity and Barter Association. The pro ses from NCBA later reported that Marsh was highly resistant to their legal advice throughout the trial because he didn't want them to represent his straw man. And on top of that, if there's a lawyer up there and you're up there and they're trying to say that you're the defendant, how can you say you're not the defendant when there's too much people up there already? Either the lawyer needs to step down because you're the lawyer of the straw man, or you need to get out of there and step down and step away from the defendant's seat because the lawyer is representing the fictitious person. Either way, they're looking for the fictitious person, so either you or your lawyer is representing that fictitious person. Now, if you and your lawyer are standing up there, that means you're taking the place of the legal fiction. You see what I'm saying? And that's the trick too, when they give you public defenders and lawyers to stand by you as if they're representing you and you're the straw man. Wrong. So these facts suggest that Marsh is relatively blind to strategy, and that his reasoning is at a proto-conscious level, with a strong commitment to being right, regardless of new information. Given Mr. Marsh's track record, we strongly advise readers of his lien to thoroughly scrutinize and research his legal theories before using any of them. So the power of commercial liens. Ease of use. Although this lien strategy is explosive, it's more like glycerin, that hydrogen bombs. Although this lien strategy is explosive, it's more like nitroglycerin than hydrogen bombs. You need to be knowledgeable and careful to use nitroglycerin, but you don't need to be a nuclear physicist. However, glycerin can blow up in your face if you handle it carelessly. Likewise, bombing government officials with liens is a craft, not a science, that can be used as easily by knowledgeable pro-pers as it can by lawyers and legal scholars. So anyone can do this if they have knowledge and light and truth and know who they are and where they stand in their system. The commercial lien is simple, inexpensive, and takes very little time. It requires no court action. It's prejudicial and non-judicial, and it doesn't need a judge's approval, a referee's approval, a middleman's approval, or a trustee's approval. And it has proven to be very direct and effective if it is handled correctly. However, a few careless pro ses or pro pers have had their liens blow up in their faces. See Chapter 5. So be meticulous when you use them. Long range. You can file a commercial lien on property in another state or on property you've never seen. With a commercial lien, you can attack the personal property of your adversary at long range rather than merely fighting to defend your own property in your own backyard. This offensive capability makes the commercial lien a powerful legal weapon even from long range as well as short range. With a commercial lien, you can literally take the fight to their backyards. The helplessness of judges. The commercial lien, which is authorized by both the common law and by Title 15 of the United States Code, USC, Title 15, USC, is reportedly the same lien the IRS uses to take Americans' homes and cars. However, some pro se or pro per litigants do not depend upon Title 15, but upon the common law of negotiable instruments, aka commercial law. Negotiable instruments can be dollars, bonds, promissory notes, promise to pays, certificates, agreements, acceptance for values, wherever your signature is at, or signatures are at, or your autograph for John Hancock, whatever you want to call it, it's all negotiable instruments, negotiable documents, negotiable paperwork. As such, it's almost impossible to remove a commercial lien without the approval of the independent spirit claimant who filed the lien. Although a commercial lien can be challenged by a common law court or by a Seventh Amendment jury trial, it does not require a court process or a court judgment for its establishment, validity, or execution. Therefore, it appears that the courts may not be able to simply extinguish this lien or their own discretion or on motion from the lien debtors without the voluntary approval of the person who filed the lien. Traditionally, these liens can only be removed by the voluntary decision of the person who filed the lien, by the decision of a constitutional common law jury trial, or by waiting 99 or 100 years. Since the common law has been smothered in the United States of America, all judges are essentially powerless to overcome the liens. So you can trample them with these liens. The right way, LAW, law. Before utilizing any of the procedures suggested in this manual, we strongly suggest that you join an organization called The Right Way, L.A.W. They are experts on legal and court procedures, as well as liens in general. They also have great expertise regarding Title 42, civil rights violation suits. For more details, see report, blah yada right here. So Chapter 2, Theory of Commercial Lien Strategy. Introduction. To effectively use the commercial lien strategy, you should have a good grasp of the principles of law involved. Immediately following this introduction is an essay written from a Christian theistic perspective explaining the foundations of the common law. The author has not copywritten this material and wishes to remain anonymous. The same author also composed several of the briefs listed in Appendix B. This explanation will, no doubt, with all certainty and faith and trust, be very different from anything you have been taught. In fact, licensed attorneys may have the hardest time understanding this because they have been taught to think only in a certain way, a very narrow way, very limited way, very tiny way, very small. An intelligent lay reader will probably understand the following article without much trouble, very easily and effortlessly. Most of us have been hypnotized into believing that the meaningless scribbles of legislators. A legislator is a man or woman who makes laws out of thin air. This is law today. Tomorrow it's not. Well, who says it apply to me with no contract and no agreement or consent? You may be injuring me, just to let you know before you proceed. Your contract don't apply to me unless you have proof. So presidents, etc., constitute, which means create. They're symbol to create the law. Constitute. Constitute mean something. Constitute mean including, things that you include, something that you make, or a statement, or a contract, or a law, or terms. Constitute what will be governing you. You see, like an institute. Con-institute. After reading this chapter, one thing should be absolutely clear to you. The law is whatever you give your consent to. This insight frees you from being a victim and a subject, and restores you to your rightful position of power and spiritual sovereignty, as well as physical sovereignty. Always remember, though, that territorial gangsters, TGs, have all sorts of ways to obtain your consent. Standing up for your rights always involves risk. The commercial affidavit process by an anonymous Christian patriot. A powerful weapon. The commercial affidavit process, or CAP, commercial affidavit process, is perhaps one of the most powerful devices available to the common man for righting wrongs and accomplishing justice. The process is not new, as some may believe. At its foundation are the laws of commerce, which spring from the eternal, immutable laws of the Most High, the Almighty I Am, pure white light spirit. And those laws have been enforced since the beginning of human existence. Alpha and Omega, beginning and end. Provoke the use of the commercial affidavit process against you, and you provoke the wrath of all that is just and right. That's what the affidavit is, the wrath of the Most High, the truth. So only the truth can set you free from the lien. Today, those who are availing themselves of the commercial affidavit process system are equipping themselves with a very powerful equalizer. Make no mistake, the cap is a very lethal weapon in the war against injustice. It is capable of righting wrongs while eliminating the cost factor that deprives thousands of people from getting justice. The expression "equal under the law" again has real meaning thanks to the commercial affidavit process. So equal under the law, we're all equal under the law. No one's above God and no one's above each other. We're all equal. When the commercial affidavit process methodology is properly loaded and cited on the wrongdoer, success is as good as in the bag. The process is powerful and dangerous to those who are in the line of fire. There is no escape, either acquiescence and justly recompense, or suffer the awful consequences. And those consequences can be calamitous, as will be shown. The foundation of law. There are basically three classes of laws. The laws of the Most High, the laws of spirit, the universal law, natural law, which is the law of God, which encompasses the laws of nature, natural. Do unto others what you want others to do unto you. An eye for an eye, a tooth for a tooth. Do not steal, do not rob, and do not covet each other's houses, your neighbor's house. This is all part of the 10 Commandments and stuff like that. The law of the land, also referred to as the common law, which is the law of nature, law of the land. And lastly, or the law of man. And lastly, there is private law, or man-made law, also referred to as contract law. So you go from being in God's law, because you have a contract with God, the Most High, Almighty I Am that I Am, Ahaya Ashur Ahaya, which encompasses respecting the natural laws of nature because the Creator made it. But then there's also the law of the land. You see, where you have to respect the land as people, as a whole. We all made laws for the land as people. And there's also, which is known as the common law, which is similar to God's law, the law of the land and the law of nature. And lastly, the private law is different from all these other laws, you see, because a private law or a man-made law takes you out of God's jurisdiction and God's contract. It takes you out of nature's jurisdiction, nature's contract, or natural contract, natural jurisdiction. It takes you out of the law of the land, or it can put you in the law of the land. It depends, you see. But man-made law is laws made purely by man. And it can put you in the law of the land or in the law of the sea, or take you completely out of both and put you into something completely alien to you. So you have to watch out with private law and man-made law, like statutes, ordinances, acts, codes, and stuff like that. All man-made. Law of the land would be the Constitution and stuff like that. Our founding fathers believed that it was self-evident that the Most High of nature, or the spirit of nature, is the sovereign of the universe and everything in it, as well as mankind, and that he had endowed all mankind with certain unalienable rights, making them self-directing sovereigns, which means that any governments instituted among men derive their just powers only from the consent of the governed, who are the source of earthly power and authority. Hence, any attempt to exercise any powers not conveyed by the people is unjust and unauthorized, and any act done pursuant to such usurpation of power is null and void, ab initio, from the beginning, nunc pro tunc. They were further convinced that God's temporal law for mankind was expressed in the law of the land. Common law is common sense law. It is simple, straightforward, and self-evident, primarily because it is based on God's spiritual laws. It is the foundational law of the union of states. The founding fathers authorized 3 legal systems in the Constitution. First, common law. Secondly, equity law. And thirdly, admiralty law, which is the law of the sea. So the law of the land, the law of money, and the law of the sea. Which is the law of the sea, admiralty. Gradually, common law has been displaced by equity, financial, bankruptcy, money law, financial law. Until today, the common law, the law of the land, is rarely heard of or understood because it has been covered up and hidden away by the legal profession for understandable business reasons, so they can make money and feed off of your ignorance and greed. Such people are pursuing their own private agenda, obviously greedy. In fact, the common law is generally looked upon as obscene. Example, to have a common law marriage is considered to be unclean. Why? The first marriage license in the United States was issued only in 1863. And how long has life been existing? You don't have to legalize your marriage and go through all these people. It's between you, your partner, and the Creator. The question is not whether some third party should or should not perform the service. It is whether sovereigns must get permission from their servants, the government, before they can get married or be married. Private law. Private law is that law which comes into being when people enter into agreements, creating the rules and terms by which they agree to be bound together. Bond. State and federal constitutions are examples of private law. They come under the heading of contract law because they are contracts that establish governments. And are designed to protect the people from the government, to keep the government under control. The people were very precise in the language they used to make it perfectly clear exactly what powers were being gave, and that any powers not specifically delegated were reserved by the people to the states or the people. It should be remembered that the people are the sovereigns of the state government, and the states are the sovereigns of the federal government. So the states are the sovereigns of the federal government. Because the people create the states and the states create federal government. Thus, the people, either directly or indirectly, are the sovereigns over both governments. The states have been given specific and limited power. They also made sure there were provisions that safeguarded the people's right to abolish or change that government and to create a different one if they choose or chose. Public law is a form of private law that results when laws are made in proper application of the delegated authority conveyed to the legislators. So public law is a form of private law that results when laws are made in proper application of the delegated authority conveyed to the legislators. Title 18, so all the laws of the people put together and the laws that have been given to the government end up becoming public law. So Title 18 of USC, Title 18 of CFR, CFR, the Federal Reserve, let me remember, CFR. Okay, Code of Federal Reserve, CFR, which they call the Federal Criminal Code. Title 18 CFR or the FCC, which is Federal Criminal Code, is an example of public law. It was drafted to grant unto non-citizens the protections and defenses citizens have under common law of the land. Title 18 does not apply to sovereign citizens who answer directly to violations of God's law. And don't call it sovereign citizen. You're a sovereign being, a sovereign spirit, a free man on the land, a natural common law man, a sojourner, who answers directly to violations of God's law, God's statutes and rules. Administrative law is one term used to describe private law that comes into existence when someone acquires dominion over others, like a debtor and creditor relationship, or employer and employee relationship, grantor grantee, trustor trustee relationship. Title 26, the Internal Revenue Code, and an example of administrative law, bankruptcy law, money law, financial law, somewhat equity law. It and the other federal titles classified by Congress as non-public administrative laws thus apply only to subjects, officers, trustees, employers of the federal government, of the federal club, that private club with that private rule. In 1938, the United States abandoned public law and adopted an unconstitutional de facto system called public policy, public policing. Now they're becoming police of this thing. They're not respecting the laws. An understanding of this distinction is so vital that the definitions of these terms follow. Public law: that portion of law which deals with the powers, rights, duties, capacities, and incapacities of government and its delegated authority. So that portion of law which deals with the powers, rights, duties, capacities, and incapacities of government and the authority that we gave to them, that we commanded them as our representative, lawyer, whatever you want to call it, a representative, delegated authority. So that's law, the law of the people. Those laws were which are concerned with the government and its political capacity, considered in its quasi-private personality, which means it's half private, half public. In other words, as capable of holding or exercising rights or acquiring and dealing with property and the character of an individual. So public policy is not the laws of the people to the government. It's the laws of the government made for the people, which is not the power we gave them. We didn't give them the power to make laws over us and tell us what to do. We had specific tasks that we wanted them to take care of and do and fulfill, and that was it. Either they can fulfill it or step down and give the seat to someone else. And obviously they need to step down and give the seat to someone else because they're not doing their job. So public policing policy, poly-ice. The rules and procedures policy of a sovereign over its subjects. So this is the rule. Public policy would be like an employer's rule over its employer, or a creditor's rules over its debtor. So a sovereign over its subjects. So they're treating us like subjects and slaves and debtors, pretty much, not creditors and creators and living, breathing men and women free on the land. It holds that no subject can lawfully do that which has a tendency to be injurious to the public or against the public good, as defined by the sovereign. So if it's injurious to the sovereign's club, if it hurts or harms the sovereign's club, it's against their policy. It's against the sovereign's rules because it's exposing that sovereign. So public policy is set by legislative acts and pursuant thereto by judicial and administrative promulgating of rules and regulations. So such rules and regulations are therefore not laws, but rather terms imposed by contract agreements. It's the contracts themselves which make these rules and regulations binding. If you are not a party to those contracts, not a subject, property of the government, you can make yourself a party by volunteering to comply, or by not disagreeing, or by remaining silent. That's all voluntary compliance. But once you decide to play the game, you are compelled by the rules of that game to continue to play all the way till victory. Once compelled, the best out is to reassert your sovereign rights. The very concept of public policy and its inherent usurpation of power from the sovereign people is so addictive and has become so widely accepted by bureaucrats in all levels of government that they act as if they were the masters of the people. So, idol worship. Thou shalt not idol worship or bow down to them. This shift in government was instituted with the Supreme Court's decision in the Erie Railroad case, as a result of which all Supreme Court decisions prior to that time, the Erie Railroad case, which is very important to know. So prior to that time, are being treated as no longer relevant in equity court proceedings. And so another milestone was reached in the conspiracy to overthrow the rights of the people. And they're getting away with more and more stuff because no one knows what to do. No one's doing what they know, and we need to start doing what we know and enforcing these things and implementing what we know and what we pretty much what we know. We have to start implementing what we know. If you're not implementing it or enforcing it, you're just as wise as not knowing it. You see what I'm saying? Like, what's the point of knowing knowledge that you can't use to do something with? It's a waste of your brain space. And so another milestone was reached in the conspiracy to overthrow the rights of the people. This administrative law is much like Roman law, English law, European law, Roman Catholic law, the PayPal bull law, which is what they call it, or the post office law, which is also called civil law. Conceptually, Roman or civil law, which is practiced in most of Europe, is diametrically opposite to the common law. Under Roman or civil law, you are guilty until proven innocent and have only those rights your master, the government, chooses to grant you, as if they're your God. These are devils and Satans, man. Who has a right to tell you what to do and how to do it? Who has the time and energy to spend trying to even do that? Break the law that bad? They must not know who they are to the point they need to get everyone lost and stuff for them to feel like they're somebody. Using everybody else's energy to feel like somebody. You ain't reaching a milestone in my spirituality. And what your master giveth, he can take away. Under the common law, as practiced in America, You are innocent until proven guilty and retain all rights not delegated to government. We are seeing more and more of this Roman class of laws in this country. If you are charged, you are treated as being guilty until proven innocent. If that is happening to you, it's because of your legal status. Calling yourself black or white or debtor, all that stuff. You see, you have to know your nationality because you're not black and white. Black and white is a color of law word. It's pretty much a mask, a deception of the real thing. You know, you're not black or white. You're either African American or Hebrew Israelite or Moorish American, or you are Moor, or whatever your actual nationality is. Black and white's a color, you see. That's why we call it color of law. It's a mask to smother the real truth and put a veil in front of it so you won't see it. Almost like having a box over someone's head and you color it all black or white and you say that's them. That's not them. You know, you're not the box. You're not the color. You're the being with the color. You see what I'm saying? And most people aren't even purely black or purely white anyway. And on top of that, black means wicked and dark and nasty and evil, and white means bright, pure and righteous. So it's not fair that they call a whole race of people wicked and stuff through the legal system. Like it's like a legal racism in a way. You see? So through your legal status, if you don't proclaim who you are, your nationality and things like that, and clearly state that you're a creditor and act like a creditor, you're going to get trampled on. On top of that, their laws only apply to foreigners, foreign domestic people who are foreign, you see? And if you're not foreign, then what is your nationality? You see what I'm saying? You need a nationality as part of your legal status, as part of the game. Because lawfully and naturally, that doesn't really matter. It's all about love, peace, truth, family, unity, justice, freedom, free will, choice. You know, all those good things. Joy, creativity, inspiration, God, humility, patience, all that stuff. That's what life is about. Not nationality and statuses and all this stuff. But we need some type of remedy in this game. We have to first beat them at their game and get back to the real thing, to the contract and covenant we have with the Most High. So it's because of your legal status, or what they perceive as your legal status, or prejudge or assume is your legal status. If your legal status is that of being a sovereign, a spiritually sovereign, natural, free man on the land, your unalienable rights are being violated. And make sure you always reserve all your rights too when you step into court and things like that. On and for the record, I exclusively reserve all my natural, religious, and unalienable rights here, now, and present. Whatever way you want to say it. Principles of lawmaking. In the days before the turn of the century in America, the custom was for those studying law to study the Bible and the laws contained therein, so that those principles would occupy a preeminent place in the minds of those practicing law. This is not the case today. Rather, the opposite is true. The eternal truths contained in the Bible, the Holy Book, have been lost from the view of those who need them the most. It is still the best place to learn about laws generally, and I agree to that. I attest to that. Amen. I affirm. As well as other eternal truths. The concept of a system of laws not founded upon those eternal truths is tantamount to building a house on quicksand. The Holy Book says that too. You can't build a foundation on top of quicksand and expect it not to crumble and fall. You need to know your rights. You need to know your foundation. You need to know your roots before you can know your branches. In America, the sovereign power resides in and comes only from the people, you and me. We, me, you, us, the people, are the sovereigns. All the power and authority the government has was given to it by us, the people, and we're still doing it. I think they need our votes. They need us. If we don't have the right to do a thing, then we cannot delegate such a right to any government. We cannot give to anyone or anything any power or authority we do not have. Like, you do not have the power to give away your rights. Not because you choose not to give it away. It wasn't created for you to give it away. Your creator created it for you to keep, and it's with you forever. It's part of your DNA. It's part of your natural vibration, your natural hum, your natural song, your natural tone, your key signature. It's you. It's part of you. To give away anything of you, it's to give away yourself. And you can't give away yourself. You see, you can only think you have and physically fulfill physical deeds, but spiritually you're bounded by the rules and laws of the Creator. You can't give away your rights, even if you tried. So it is not in controversion to this principle that representatives of the people, legislators or bureaucrats or judges or policemen, pretend they can make laws to implement powers we the people did not and cannot give them. So is it not in controversion to this principle that representatives of the people pretend they can make laws to implement powers we the people did not and cannot give them? It is self-evident. Go within, close your eyes, meditate, ask yourself, who am I? Who are you? Why am I here? Where do I stand? Who created me? Who created my mom, my dad? Who created their mom and dad? Who created humans? Who created the sky? Who created all the animals, the fishes, the birds, the beasts on the land? Who created them? Who created God and the devil? Who created all of this? Whoever it is, I don't know what it is. I know it's with me. I can sense it with me. You can call it prime creator. You can call it source. You can call it God. You can call it Ahaya. You can call it I am, I am. You can call it whatever you want to call it. But what is it? Who is it? Where is it? And what is my rights in its world? And that's what you will find becomes self-evident, that you cannot give powers that you don't have. They want the world. They want the universe. They want to claim their God. You can't give them that power. You can only invest in them and bow down to them and all this bullshit you're not supposed to do. But other than that, you can't make them God. They can never be God. No matter how much people believe in them, even if everything in the universe believe that one man is God except God, they're still not God. They just can't be. They just have a lot of fools that follow them. So you must connect with the true living God, the true living creator. I am that I am. Exodus 3:14. Yet they pretend they can do virtually anything they, or even a majority of them, merely agree among themselves, vote to do. They publish interpretations of laws and promulgate rules based on those interpretations, or they render decisions that are clearly antithetical, pardon me, that is clearly antithetical, which means anti-God or anti-creator, to the concept set forth in the Declaration of Independence, because we're independent, depending on the end, and the Constitution as the Founding Fathers understood and expounded them, and thereby they violate their sworn oath to defend and uphold the Constitution, or the covenant with the Creator, Ahaya Shurahaya, the almighty pure white light, the highest self, the greater I am. They know that few, if any, who discover such usurpation will have the perseverance, let alone the financial means and time required to find a qualified, willing attorney to utilize the court system to expose their usurpation and bring them to account, and thus rectify their malfunction. They also promote and rely on the general misconception that any statute passed by a legislator is valid. It is impossible for both the Constitution and a law violating it to be valid. One must prevail. This is succinctly stated as follows. The general rule is that an unconstitutional statute, though having the form and name of law, is in reality no law, but is wholly void and ineffective for any purpose, since unconstitutionality dates from the time of its enactment, and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is an inoperative as if it had never been passed. Since an unconstitutional law is void, the general principles follow that it imposes no duties. Remember this, write this down. It imposes no duties, no terms, no agreements, no job, nothing mandatory. You're not obligated to anything. Imposes no duties. It confers no rights. It's not giving you rights. It's not giving you benefits or anything. It creates no office. So if there's no constitution, no oath of office, there's no office. Because it's the oath in the Constitution and the promise that makes the office, the credibility of the person. And it bestows no power or authority on anyone, which means it doesn't have any power over you. It's unenforceable. It's null and void. And it has no authority over you, which means it doesn't give jurisdiction. It's lacking it. It affords no protection. So it's not giving protection to anybody. And it justifies no acts performed under it. So there's no justice in the unconstitutional law. It's unconstitutional. There's no justice in that type of law. So no one is bound to obey an unconstitutional law, and no courts are bound to enforce it. 16 A.M. Jur. 2nd Section 177. So now if you want to check out that court case where this is sourced from and cited from, you can go type that into Yahoo or Google search and it will pop up the case. The general rule, quote unquote, is that an unconstitutional act of the legislator protects no one. It is said that all persons are presumed to know the law, meaning that ignorance of the law excuses no one. If any person acts under an unconstitutional statute, an unconstitutional private foreign, international, incorporate, private code, he does so at his own peril and must take the consequences. 16 A.M. Jur. 2D, Section 178. Quote unquote, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Miranda v. Arizona, 384 U.S. 436 at 491. In order for a law to be proper, it must be just, fair, and equal, and reasonable. It must protect equally the rights of all, without violating the rights of any. There is nothing mysterious, my story, about proper law. It is based on reasonableness and common sense, and is harmonious with the laws of God, the Almighty I Am, the greatest I Am presence, pure white light. Check a law against this measure to see if it fits the mode of eternal truth and justice. Say to yourself, would I be unwilling to have this law applied to myself or my closest friend? If such application seems repugnant to you, if it seems unfair or unjust to you, then there is probably something wrong with that law. God knows the people's political standards are a reliable reflection of their moral standards, and that the laws which they support are a good test of how they wish to be judged. Matthew 7, Section 1. People can clearly see that taking money from someone by force is a crime when done by individuals, but they may fail to recognize the criminality of the same act when done by government. For example, how would you feel if you had a particular entitlement and the government told you that you were authorized to collect a portion of this government handout from each of your neighbors? So what if the government told you that you have the power and right to go steal everything from your neighbors and you won't go to jail and nothing bad would happen? You probably would take advantage of that. You see, so we're the government of the government, and we pretty much let them take things from people and gave them the power, or didn't take the power away from them, to steal from us and rob us and trespass our will in our field, our energetic field. Therefore, we're giving them a paradise, a consensual paradise to infringe on our rights every day and invade us. You see? So imagine if your government told you can go rob anyone, do what you want, you won't go to jail. Let's suppose that your entitlement is food stamps. Instead of giving you stamps, the government gives you a list of people from who you are authorized to collect the money to buy the food. How would you feel if they told you it was all right to force your neighbors to give you the money? And you won't go to jail, you won't go to court, nothing. Try it. Imagine if they told you that. Would you do it? And every time you needed more food, you had to do it all over again, rob someone else. Would that be right? If not, why? Would changing the name of the collector make it right? Would it go against your grain to do so? How would your neighbors feel when you presented your authorization? How would you feel if your neighbors were coming to collect from you, from me, for some other entitlement program they were authorized to collect? Quote unquote, quote, authorized. The commercial affidavit process is a pre-common law process. It is also referred to as a commercial law process, not to be confused with the Uniform Commercial Code, UCC, and other manipulated and complicated rules and regulations. It is a pre-common law process because until there is a disagreement, there is no dispute. There got to be some controversy, some dispute, some argument in order for a case to be made or a process or anything that has to do with court. So if they don't rebut or argue with what you say or refute it or disagree with it, they're pretty much agreeing with it because they're not arguing with that. You see? All that is being done is the establishment of claims and obligations. The purpose of the commercial affidavit process is to make claims and determine if the accused agrees or not. If the accused does not contest the claims, there is no dispute to be adjudicated. Thus, the appropriate damages are consensually agreed upon. Thus, it is prejudicial. It may also be completely non-judicial if it is properly composed of unrebuttable truth and successfully implemented. The term commercial as used herein refers to any dealings people have among themselves. Thus, the laws of commerce refers to the just rules of procedure governing human relationships, the self-evident principles of right and wrong, which are the foundation of the common law of life. The foundation of commercial law rests solidly on the bedrock of justice and common sense. These laws are so sound and so universally accepted that they cannot with impunity be overturned, overwritten, or tampered with in any way. They are founded on eternal truths, needing no proof from anyone to justify their validity. In other words, it's self-evident. They are immutable. They provide equal justice to all parties of interest and thus are completely fair. That is the key to their power. All other just laws spring from this foundation of truth. By contrast, corrupt laws are mere shadows of these true and correct principles. Justice is delivered quickly, simply, fairly, and conclusively with the commercial affidavit process. This may be a terrible disappointment to wrongdoers who are confident they can get away with their illegitimate activities. Those who are subverting just laws, setting them aside, covering them up, creating shadow law or colorable law, and just generally using self-serving laws to subject and plunder their fellow man, are in for a rude awakening. In summary, the common law grows out of the laws of commerce, which themselves are based upon self-evident truths. Such truths are commonly expressed as maxims. So maxims in law, maxims are as much a part of the laws of human relations, commerce. As a foundation is a part of a building. They are fundamental and immutable, having their basis in God's laws, spiritual laws. No one of sound mind argues against them. They are the bedrock of logic, of reason, of common sense, of truth. They are fundamental principles upon which all that is right, just, and true is founded. They are the standards to measure the correctness of any course or action. The word maxim is defined as an expression of an absolute truth or principle. Maxims are so powerful and unequivocal that they are the foundation of all human relationships. They have the power to cut to the heart of a matter in a heartbeat with reason, logic, and authority. Maxims are universal. They cover every topic imaginable in every aspect of our lives. They are not easily misunderstood, misapplied, or subverted. They are usually accepted for what they are, self-evident truths. Universal self-evident truth are natural and universal self-evident truths. Maxims might be considered the redundant backup system when all else fails. Anyone who is not schooled in the logic of maxims is easily confused for the want of such understanding. The legal profession has a vested interest in keeping the people ignorant of these principles, protecting the need for their priestcraft. Priestcraft is a craft of specialists who work to create the illusion. Their craft is too complex to be understood by anyone else. It doesn't take a law degree to understand natural common laws, maxims, spiritual laws, God's law, and etc. The light of truth, truth is light, and maxims cannot be extinguished through the evil works and craftiness of men. They may be forgotten by many intentionally, concealed by some, but they still exist no matter what, and they won't go away. Below are maxims that surround the rightfulness and lawfulness of the commercial affidavit process. This by no means is an exhaustive list. So you will want to use some of these maxims in your affidavits because they're self-evident. It makes sense. It's universal. You see? So always include these in your affidavits. So regarding justice, all are equal under the law. A matter must be expressed to be resolved. Claims made without accountability are void. Might does not make right. Force, perjury, a subordination, subordination of perjury voids all. Fraud vitiates the most solemn promise. While the battle continues, he who first leaves the field or refuses to contend loses by default. You are free to make any decision you wish, but you are never free to escape the consequences of your decisions. A laborer is worthy of his hire and of their pay. A workman or a worker is worthy of their pay. Thou shalt not steal. You should not steal. Notice to the agent is notice to the principal, and notice to the principal is notice to the agent. And this is important to put on your affidavits as well, so they know that you're not the principal straw man, you're just the authorized agent. So the notice that's going to the agent is going to the principal, and the notice that's going to the principal is going to the agent. Do unto others as you would have others do unto you. So now regarding truth. Truth stands supreme. Truth affects but cannot be affected. Truth is expressed in the form of an affidavit. Truth will out. An unrebutted affidavit stands as the truth. An affidavit must be rebutted point for point. Thou shalt not bear false witness. Ignorance is no respecter. It affects all without regard to position or title. Now regarding sovereignty. It is self-evident that all men are endowed by their Creator, the Almighty I am that I am, Ahaya Shur Ahaya, Spirit, God, Prime Creator, with equal and unalienable rights. The created cannot be greater than his creator. A man can give to another no more than he himself has. A man can give to another no more than he himself has. A man may not with impunity infringe upon another man's rights. The people are sovereign. Spirits are sovereign. In America, the government is the servant of the sovereign people. Now, regarding power and authority, we cannot give to anyone or anything any power or authority we do not have. So, failed legal system. Although the court system may have an essential part to play once the commercial affidavit has been served and answered, that system is not and cannot be invoked until the charges and the affidavit have been answered by 1. Acquiescence, 2. Rebuttal, or 3. Default. Until that point, there is no disagreement to adjudicate. A disagreement could arise only from a rebuttal. So if I was you, I would put that in the in your affidavit somewhere as well. The only 3 ways to extinguish the lien: either paying it off, rebutting it point for point, or don't do anything at all and enter default, and I'll do it for you. I'll choose what I believe you are trying to say through your silence. So, but even though it would be feasible to involve the court system to adjudicate such disagreement, no one seeking justice really would want to do so, because the court system has become extremely costly, very slow, and corrupted by the conniving convulsions of man-made rules and legalisms, the language of the legal world, which is called legalese, and by the natural inclinations of those who live from the legal system to promote the financial success of the legal business. If any adjudication is found necessary only in the event of rebuttal, it will be done by a common law jury, invoked at the discretion of the claimant. See resolution by jury below. In stark contrast to the equity court system of today, the commercial affidavit process system is so effective in exposing the truth and rendering and enforcing justice that it is a lethal weapon in the war for the freedoms and liberties, the unalienable rights of the people. Private matter. We're going to be pausing. Let me see. Let's see where we're going to be pausing. Alright, so we're going to be pausing in a few. We're going to read just a few more pages and we're going to be done there. Alright, private matter. The commercial affidavit process places the full power of pardon me. Did we read this? Alright, let me finish this up. In stark contrast to the equity court system of today, the CAP system is so effective in exposing the truth and rendering and enforcing justice that it is a lethal weapon in the war for the freedoms and liberties, the unalienable, unalienable rights of the people. Private matter. The commercial affidavit process places the full power of justice back in the hands of the common law man, of the most higher, the almighty I am, highest self. It cannot be overstated that the whole commercial affidavit process is not dependent on the court system. It functions quite well on its own outside the current legal system. It needs to be thoroughly understood that because it is driven by sworn truth. The commercial affidavit process is outside the jurisdiction of an equity court. It is a private contract matter. Should an attempt be made to involve an equity court, it would result in a trespass against the affiant's rights. Those interfering individuals who were unlawfully involved would themselves become one of the accused. An equity court has no jurisdiction whatsoever, for the commercial affidavit process is strictly a non-judicial or prejudicial process between individuals and is private. So make sure you put on your affidavit private matter. This is private matter, which will mean private and confidential, and also non-transferable. Well, you can make it. Don't put non-transferable on it because you're gonna need to be able to transfer it to sell it and stuff like that. This alone presents a very real dilemma for those who are accustomed to using the legal system to work wrongs and trespass against others with seeming impunities. They can't hide behind a legal system that only dispenses justice to those who can afford to play the game. Those who are used to shielding themselves under sovereign immunity protections, hiding behind legions of attorneys and judges, and using other legal tricks now have none of this protection. No judge, court, law, or government can invalidate these commercial processes. In other words, an affidavit or complaint or a lien based thereon, because no third party can invalidate someone's affidavit of truth. A judge cannot interfere with, tamper with, or in any way, shape, or manner modify testimony without disintegrating the truth-seeking process of his profession, destroying the very fabric of his own occupation, and abrogating the First Amendment, which was established to protect truth. For a judge to interfere with testimony is to commit professional suicide and to invite countless civil and criminal repercussions. Recusal, indictment, to be impeached and removed. Anyone who tampers with testimony is a threat to the peace and security of society, violating its laws and acting as its enemy, and is therefore justifiable subject to the appropriate penalties. The commercial affidavit process is by its very nature private, and strictly between parties of interest only. No third-party interveners or middlemen and all that stuff. It's between the accused and the accusing. It is unequivocally non-judicial. Sworn truth, the foundation of the law. The foundation of the law, commerce, and the whole legal system consists in telling the truth. I solemnly swear to tell the truth, the whole truth, and nothing but the truth. I affirm, either by testimony, by deposition, or by affidavit. Every honorable judge requires those who appear before him to be sworn to tell the truth, and is compelled by the high principles of his profession to protect and seek out the truth. Because that's all that matters in the court. Evidence, truth, contract, proof of consent, agreement, something. Or they have no case, no subject matter jurisdiction. A commercial affidavit is an affidavit of truth. It is the sworn testimony of the affiant who solemnly swears that the facts contained therein are true, correct, certain, and not misleading. Every claim made in the affidavit is backed up by documentary evidence that is provable without any contravence. Meeting the demands. If, as is usually the case, the accused recognizes the charges are true and or decides correctly that the wisest thing to do is meet the demands rather than face the staggering punitive damages which accompany the issuance of the criminal complaint, the accused has the option of simply meeting the demands for readdress, as required by or negotiated with the claimant. If the accused has the good sense to meet the demands of the claimant, then the wrongs have been satisfactorily redressed, and that is the end of the issue. All charges are resolved, forgiven. The commercial affidavit process is closed. So this is how you can seek remedy in this system. Anyone is free to use a commercial affidavit process system, but it is a two-edged sword. It cuts both ways. Anyone who undertakes it must follow the maxim, be honest with yourself, because especially under the commercial affidavit process, truth will out. Consequently, it is extremely important to ensure that everything in the affidavit is true and unrebuttable. And if you have no proof or evidence of what you're stating, do not state it, or you might get in trouble. If it's something you heard, hearsay, all that, do not use it unless you have proof. Undeniable proof. And this is what you're putting in your affidavits. Acquiescence. When one is the accused in a commercial affidavit process, properly, truthfully done, by far the wisest course is to redress the claimant as demanded, whatever must be done to accomplish it. Should the accused be misguided into choosing any response other than acquiescence, the criminal complaint will issue accompanied by the commercial lien based on the complaint's ledger of charges, counts, redresses, demanded, and adding 1. Punitive damages, 2. Incarceration as provided in the applicable federal and or state criminal codes. So alright, should the accused be misguided into choosing any response other than acquiescence, the criminal complaint will issue accompanied by the commercial lien based on the complaint's ledger of charges, counts, redresses, demands, and adding 1. Punitive damages, and 2. Incarceration as provided in the applicable federal and or state criminal codes. Although it is extremely unlikely in the face of a properly done affidavit, should the accused believe that affiant's charges is somehow in error, he or she may, during the grace period only, because you have a grace period in all affidavits and you must give a grace period, opportunity to cure. And if he or she may rebut any such charge, however, 1. Such response will not avoid issuance of the trial criminal complaint. 2. The commercial lien will still issue for any charges not rebutted. And 3. A second commercial lien will issue for any rebutted charges about which the common law jury, thereby convened, remains unpersuaded. Hence, rebuttal, unless 100% successful, which is highly unlikely, will not avoid the horrendous punitive damages incarceration provided by law. So you can actually go to jail for not paying these charges and these fees, the lien. You see, you have to give up something to fulfill it. All right, rebuttal. The sworn affidavit will stand as truth if not timely rebutted by the accused. In the instant case, 30 days, 3 days minimum in accordance with the Truth in Lending Act. 3 days minimum. You have to cancel any contract, rebut any contract, and not relinquish, but revoke every contract. 3 days, 72 hours the most. The only one who can rebut a commercial affidavit is the accused, who alone, by his own affidavit, must speak for himself and only for himself. If the accused uses someone else to speak for him, the third party must speak for and in behalf of the accused, as if he were the accused. Because remember, it has to be the truth of the accused, not the attorney, not the lawyer, and all this stuff. And the accused still stands completely liable as if he himself were speaking. If, however, the third party is identified as separated from the accused, he also becomes a co-party with the accused as an accomplice, thus a co-conspirator, having no immunity whatsoever. Every charge or claim contained in the claimant's affidavit must be rebutted point for point for point by the accused. The accused rebuttal must be done in the form of an affidavit of truth. That means it must be sworn testimony. It must be signed by at least 2 witnesses or a notary. And witnesses, which would be great. The accused, affiant, must swear to the truth, the correctness, and the certainty of his or her rebuttals within that affidavit, thereby assuming complete liability for the statements contained in it, and must be prepared to prove his or her statements, preferably with documentation that is unimpeachable. So failure to follow the correct process of rebutting the charges, or any attempt to present rebuttal evidence that is not sworn as both true and the whole truth, invalidates such response as if no evidence or rebuttal were given at all. Such failure is fatal to the defense. So if a proper rebuttal is offered, any of several conclusions may result. 1. If any or all charges are rebutted, those charges will, at claimant's discretion, be resolved as described under resolution by jury. 2. Any charges not rebutted or redressed will result in a default conviction for those charges and the issuance of a non-trial criminal complaint, which will be covered under criminal liability. So any charges not rebutted or redressed will result in a default conviction, a default. Resolution by jury. The claimant may accept or reject accused rebuttal of any charge, point for point. Claimant's acceptance of the rebuttal of any point resolves that point. At the discretion of the claimant, all unaccepted points may be either resolved by another affidavit on those points, repeating the process. The fallout of all the affidavits are resolved by a common law jury. If and when the jury system is used, the claimant will draft the criminal complaint, subpoena a jury, and the process will move to a full-blown common law criminal trial. If the matter goes to a common law criminal trial, the trial will be held under the rules of common law. These rules are significantly different from those in an equity court proceeding. In common law trials, technical rules are virtually non-existent. Like its name, the rules of common law trials are from common sense. The procedure is very simple and straightforward. It's designed to arrive at the true facts, assesses guilt, and render a just verdict without undue delays or fancy maneuvering, thus eliminating delays intended to forestall or get the accused acquitted on some technicality. The jury is the real boss. It decides what is relevant and what is not. The jurors hear what they want to hear and exclude what they feel is not relevant. The claimant or his appointee becomes the prosecutor. So the claimant or his appointee becomes a prosecutor, and the accused or his appointee becomes the defense attorney. The parties of interest, the claimant and the accused, may have anyone they want as counsel, professional or not. The risk faced by the accused is very real. A common law court only recognizes common law, and it applies common law decisions. Equity court decisions and rules that conflict with the common law are without standing in common law proceedings. In the commercial affidavit process, the claimants are almost always sovereign beings. Free men on the land, free man or free woman on the land, sojourners. As such, they have legal standing at common law. The accused are usually subject citizens, being charged with crimes against sovereign beings, sovereign creditors. Typically, the acts committed have been done under colorable law, de facto law, with colorable de facto authority, or colorable de facto jurisdiction, in which case is patently unconstitutional and therefore null and void ab initio, nunc pro tunc, leaving the accused defenseless. So a second commercial lien will issue for those redresses and punitive damages of which the jury has not exonerated the accused. Alright, due process. In order to meet the demands of due process, the parties must have reasonable time to express their versions of the controversy. In order for a matter to be resolved, it must be expressed. Therefore, a grace period must be allowed, commonly referred to as a commercial grace. Many court jurisdictions allow only 20 days, which may be sufficient, but the claimant in his discretion believes but the claimant in his discretion believes that 30 days is more reasonable. At the claimant's discretion, even more time may be granted without notice. However, that does not relieve the defense of the obligation to respond within the time of commercial grace given. The default falls by declaration in 30 days. How important is it to timely answer the accusations made in the sworn affidavit of truth? It is vitally important. If the accused failed to properly and timely answer, he stands to lose all and will have foreclosed to himself any future possibility of redressing or rebutting those charges. The primary objective is to ensure justice quickly and with a minimum of difficulty. Failure to timely answer is fatal to the outcome. It is equivalent to abandoning the battlefield or abandoning the ship and causes loss by default. While the battle continues, he who first leaves the field or refuses to contend loses by default. So if the judge leaves his seat without adjourning and not coming to a fair conclusion, and they leave the seat and they leave, they're the first to leave the ship. Now you are in charge of the ship. You're captain of the ship. Whatever you state, whatever you term, whatever you condition will be the judgment. That will be what stands. So the accused, having started the contest by violating and trespassing upon the affiant's rights, which is you, cannot with impunity leave the contest. The victory and the spoils go to him who stays and is the last to leave the battlefield. The loser loses and in so doing grants the spoils to the victor, whatever they leave behind, even the court. There is no recovery for the loser, notwithstanding any new battle which may ensue. The loss still stands. It can't be set aside. Consequently, the accused's failure to address or rebut charges contained in a commercial affidavit is tantamount to abandoning the battlefield, thus losing by default. Hope you get that. It's very important. So you're hoping they don't rebut. You're hoping they don't reply. Some in government, by trying to hide behind some rule or procedure that requires claimants to follow some predetermined course or time limit, commit a fatal error. They are usually relying on some statute or other inferior level of protection, which might apply to those who are subject or officers or employees to such jurisdiction, but not to sovereign free men on the land or free women on the land, sovereign spirits, sovereign beings, sovereign souls. When estoppel by acquaintances caused by failure to timely answer and enters the picture, as it surely will in this setting, the result has a far-reaching impact on the future of each accused. Alright, so this is definitely where we're going to stop at criminal liability, because the Security Exchange Commission, which is where they usually trade all our Security Exchange Commission, we can also use there to sell the debts, the ledgers, the obligations, the promises to pay, the bonds, all that stuff, to convert it into account receivable. You see, into an escrow account and stuff like that, and then you can 1099 A it or 1099 OID it to shut that account and to pay off that whole charge, whatever you may be owing or whatever. But you actually get paid for these bond papers and these promise to pays and these affidavits and stuff. You see, they become accounts receivable. They become a type of asset. So there's more to learn about that. I'll talk about that on part 2 of this video. So the criminal liability. Responding to the commercial affidavit is critically important. The accused is usually being charged with very serious crimes that carry very heavy punitive penalties. The law has always viewed trespassing upon unalienable rights as being an offense so serious that it is beyond satisfaction merely by payment of the approximate money damages demanded or stipulated in your affidavits. Because you have to put penalties in your affidavits too. Punitive damages and costs. The affidavit is a commercial complaint, but it is not yet a criminal complaint. The main distinction is that by resolving the charges during the affidavit stage, The accused can get off by simply redressing the grievances as specified in the affidavit or as mutually negotiated, non-judicially or prejudicially. If the accused recognizes his or her errors and wants to redress the claimant but does not have the ability to do so within the time limit, the accused may contact the claimant and express that desire with a written statement to that effect. Then arrangements can be made to stop any further action. If some such arrangements are not made, then the criminal complaint issues, adding punitive damages and possibly jail time. The criminal complaint is in reality a ledger in which those details which were omitted in the affidavit are now spelled out. It lists the causes of action, the number of counts, redresses demanded, and and the massive civil penalties which occur when unalienable rights are violated, thus compounding the problems for the accused. Now, on top of the redresses being demanded, massive punitive damages are added as well. This you're eating at their pocket. So it turns into a ledger, a form of money, form of dollars, form of value now. Now they owe you something because they took something from you. Now they owe you. And in your affidavits, make sure you list the cause of action, the number of counts, the redresses that you're demanding. What do you want? What remedy do you want? Because you're coming with the remedy and redress, so you got to know what you want. And the massive civil penalties or penalties that you're going to be putting on them, as well as your evidence and everything like that. And you got to make sure you got to definitely you got to make sure that you put the maxims in your affidavits and everything. So write all of this on paper. Take note as we go. All right. Normally, this increases the cost to the accused by a factor of at least 100, if not 1,000-fold. The effects of the criminal complaint invariably destroy all prospects for the future of the accused. So we're on page 18 now. We'll continue on in part 2. I hope you guys learned a lot today. And if you have any questions, just contact me. Like I said, I have already read this already. It's been very informative. It reinforced and confirmed everything that I already believed and thought in anyway. So if you've been wondering how to sue anybody or get your property back or anything, the lien is your best bet. And we'll learn the process of how to do it in part 3 or part 2. We'll see. All right, everyone. I hope you all have a wonderful day. Live in peace, live in love, and let the whole world unite in peace, love, and justice. Aman. Shalom.